Hi, my name is Chris Yukins. I'm a professor at George Washington University Law School in the Government Procurement Law program there. I'm going to be talking to you today about the new EU foreign subsidies regulation. This is part of a program, Challenges for Public Procurement in Europe and Beyond. It's a concept program. It's going to be held in Brussels on June 7th, 2023. I hope to be able to join by webinar, but if I can't join, I wanted to have this recording available to outline my program presentation. Thank you. So as I said, I'm a professor at George Washington University Law School. I'm the Lynn David Research Professor in Government Procurement Law at GWU. GWU at the law school offers JD, Master's, and Master's in Law degrees in procurement law, both for students in live sessions and online. Our program was founded in 1960 by Ralph Nash and John Savinik, and we regularly work both nationally and internationally in the program. We recently had a webinar called A New Barrier to Transatlantic Procurement, the European Union's Foreign Subsidies Regulation. That is available on publicprocurementinternational.com. It's my blog, and it's also available on the YouTube page for the GWU Law Government Procurement Law program. There are extensive materials that I'll be citing during the presentation today, including a government contractor article that I wrote in conjunction with Pascal Friton and Max Klasse, who are two partners at the Blomstein law firm in Berlin. All of these materials and other materials that I'll be citing are available on the publicprocurementinternational.com website. The EU foreign subsidies regulation is a very interesting development in terms of international procurement trade. The idea behind it is to level the playing field for European Union vendors internationally. The foreign subsidies regulation would impose the EU state aid doctrine on foreign vendors who are competing in EU member state procurements. The state aid doctrine is a doctrine that's simple in concept, but very complex in implementation. The state aid doctrine is a set of rules that the European Commission will apply to member states to limit the types of subsidies that the member states can afford their businesses or their citizens, with the idea that those subsidies could disrupt the efficiency of the internal market, the unitary market in the European Union. So the idea behind the foreign subsidies regulation with regards to procurement, it affects other areas as well, but with regards to procurement, the idea would be that foreign vendors competing in the EU member states would have to disclose the foreign government subsidies that they're receiving, and the Commission will review those subsidies. It would be applicable to civil agency procurements above 250 million euros, and it's being implemented this year. It would also apply to defense procurements because the European Commission could undertake ex officio will be able to undertake ex officio investigations of defense procurements as well. In practice, this foreign subsidies regulation imposes a huge administrative burden on vendors who need to comply coming in from abroad, because it requires them to assess and disclose all the potential foreign subsidies that they may be receiving from their home governments. It could also be used strategically by competitors, say by other EU vendors who seek to complain about foreign vendors who haven't, in their view, adequately disclosed their foreign subsidies. So in essence, the foreign subsidies regulation could be another weapon used in what we would call a bid protest or a challenge or remedies proceeding in the European Union. So their foreign vendors will have to incur substantial costs complying with this, and they face potential disqualification if it's found that they haven't fully complied. I want to talk just briefly about practical implications with it, working through a practical example with you. In this example, an EU prime contractor has to choose between two potential suppliers, one from outside the European Union, say from the United Kingdom or from the United States. And this would be a main supplier, a supplier that played an important, integral role in the overall project. And the alternative, the European Union prime contractor bidder could choose to use an EU vendor or supplier as a subcontractor or supplier. If the EU supplier is used, there's not going to be any disclosure required under the Foreign Subsidies Regulation. But if the non-EU supplier is selected by the prime contractor as a partner in this project, there would be substantial disclosure obligations on the Foreign Subsidies Regulation. I want to just compare these two situations between the green and the red here, between the EU supplier versus the non-EU supplier. Now that creates possible issues. This discriminatory impact between the EU supplier versus the non-EU supplier creates potential discriminatory impact. And two lawyers in Europe have assessed this through a publication produced about the FSR, about the Foreign Subsidies Regulation by Wolters Kluwer. Rebecca Halbach and Emmanuel Rogis assessed this under various trade agreements, including the government procurement agreement. And they pointed out that this may be a violation of the government procurement agreement, may well be a violation of the government procurement agreement, because in essence, there's discrimination between suppliers. Article 4.2 of the government procurement agreement is, which is the leading government procurement, leading trade agreement governing procurement in the international marketplaces. Article 4.2 provides that with respect to any measure regarding covered procurement, a party, including its procuring entities, shall not discriminate against a locally established supplier on the basis that the goods or services offered by that supplier for a particular procurement are goods or services of any other party. So going back to our example here, if the prime contractor, the EU prime contractor, chose the non-EU supplier because that was the best solution, arguably the EU prime contractor would suffer discrimination because it and the non-EU supplier would share significant risk, significant burden, and significant risk through the disclosures and through the potential disqualification caused by the FSR. They would arguably suffer severe discrimination compared to the EU supplier. So it appears that the FSR may well trigger a violation of the government procurement agreement and other similar trade agreements that the European Union has entered into. But we want to focus here on the GPA and the government procurement agreement. The U.S. Chamber of Commerce has actually recommended to the European Commission that members of the GPA, other nations outside the European Union, you can see them here on this map, it's the green nations outside the European Union, that other nations outside the European Union that are members of the GPA simply be exempted from the Foreign Subsidies Regulation. This is a recommendation that's not without precedent. The International Procurement Instrument, which has also been launched by the European Union, which is a way to potentially discriminate against vendors from nations that have not opened their own procurement markets equitably to European Union vendors. The IPI, the EU International Procurement Instrument, does explicitly exempt GPA nations, and the same might well be done here by the European Union because of the potential violation here of the GPA, and that's really what informed the recommendation from the U.S. Chamber of Commerce that, in fact, the GPA nations be exempted. It's also worth stressing that the reason to exempt the GPA nations is that if the FSR, the Foreign Subsidies Regulation, goes forward, it threatens to undo the entire fabric of international procurement trade, because it'd be very easy to flip this upside down. Essentially what the FSR does, applies a home set of norms from the European Union. The state aid doctrine reflects European norms, reflects European rules, reflects European expectations about appropriate state aid, and applies them to foreigners. If that's were flipped around, if, for example, the United States started punishing European vendors because, for example, their technicians or their lawyers received subsidies through their education, their massive subsidies in the European Union to institutions of higher education compared, for example, to the United States. If the United States flipped it around and started applying its own home norms to European vendors coming in and imposing penalties on vendors that received those alleged subsidies, quickly, the international trade order regarding procurement, this free trade order that's been set up through the government procurement agreement, really since World War II, that could fall apart. So there are compelling reasons for exempting the GPA nations from the FSR. That's it on my presentation. If you have any questions, please feel free to contact me at cukins@law.gwu.edu. Thank you very much.